a few common types of defenses that we typically see in possession of a controlled substance cases. The first type of defense is what we call an affirmative defense. In those scenarios, an accused person says, yes, in fact, I did possess the substance at issue. However, I had a valid prescription from my licensed medical doctor at that time. Therefore, it was not illegal for me to possess the substance. And in those cases, the charge should be dismissed. The second type of defense that we see in these cases can be summarized as constitutional challenges. We typically see these in challenges to unlawful searches and seizures under the Fourth Amendment. For example, in order for law enforcement to search a person's person or property, they must either have a search warrant or be able to prove that a warrant exception existed at that time. If it did not, and the controlled substance was found as a result of an unlawful search, an attorney can argue that the results of that search should not be admissible at trial, and therefore the charge should be dismissed. Similarly, if there is a search warrant at issue, and either the search warrant lacked probable cause or was deficient in not specifying the areas to be searched or the items to be searched for, an attorney can similarly argue that the fruits of that search should be deemed inadmissible at trial. The third type of defense that we commonly see centers around the possession element of these charges. In our last video, we discussed how there are two different types of possession, those being actual and constructive. In constructive possession cases, for example, there can be a home where there are multiple people living there and a controlled substance found in an area that doesn't necessarily belong to any specific person. Or another example is when multiple people are pulled over inside a vehicle and a controlled substance is found in that vehicle, again in an area that's not necessarily in control of any person in that vehicle. A defense attorney can argue that if the accused person did not have any reason to know that the substance was there, they could not exercise dominion and control to possess that item, and therefore the charge should be dismissed because the prosecutor cannot satisfy the possession element of the charge. If you or a loved one happen to be dealing with such a charge, it is important that you contact a local defense attorney to discuss if any of these defenses might be applicable to your case and any other way that a defense attorney might be able to help you.